Entity Selection and Critical Documents. Prepared for and presented at the 2019 Square One Entrepreneurship Training Program. Square One is a program of the Center for Emerging Technologies. CET is an affiliate of the Cortex Innovation Community. Square One is funded in part by the Missouri Technology Corporation.
My goal when we work with early stage companies is to help them form a solid legal foundation. That solid legal foundation gives you a place to start and grow. We were just talking about this analogy the other day, and I think it's really fitting for this group. If you're going to build a skyscraper, you have to have a really solid foundation, and your legal documents are a part of that. So let me start by telling you who I am. My name is Sara Stock. I'm the founder of Stock Legal. I've been a practicing lawyer for 17 years and an entrepreneur for 5 of them. I was an equity partner with Lewis, Rice & Fingersh, big firm here in town, until November of 2014. I left to start my own practice, joined up with 2 partners in November of 2014, and then ultimately started Stock Legal January of 2017. In November of 2014, it was me and 100 clients. Today, we're soon to be 13 lawyers and over 4,000 clients. So we've grown exponentially, and our focus are companies just like yours. I describe it as small to medium-sized businesses. They're pre-revenue to about 100 million in annual revenue. And we only do very specific things at Stock Legal. We help people form companies, we help them raise capital, we do all kinds of general contracting, mergers and acquisitions, helping people buy and sell companies, commercial real estate, helping people buy and sell real estate and also lease real estate, intellectual property, and estate planning. So what I'm going to talk to you about today is squarely within our wheelhouse and much of what you're likely dealing with as you're getting ready to start a company or have just started a company. So just so I can get a sense of where you guys are at, how many of you have an entity already? Excellent. And how many of you have an idea and you're getting ready to form an entity? Okay, excellent. So I'm going to start with entity selection, but I won't spend a whole lot of time on it. I'm going to try to keep an eye on the time too, because I'd like to make sure that I leave some time for questions at the end, but I'm also going to pause at the end of each section to see if you have any questions on the material that I've presented thus far. So entity selection, where you're at right now, really looks like 3 questions. Are you going to form a limited liability company? Are you going to form an S corporation, or are you going to form a C corporation? Just out of curiosity, how many of you who have a company have an LLC? Okay. And how many of you have a corporation of some sort? Excellent. Okay. So let's start with a little bit on the formation of a limited liability company. The vast majority of you have an LLC, and that's generally my advice too. I say generally because there are always specific facts and circumstances that might lead us to say corporation. I look at the LLC approach as the do no harm approach. You can start out as a limited liability company and almost always make the conversion from an LLC to a corporation without any negative tax consequences. In fact, I spoke on a panel for the American Bar Association 2 years ago now, brought in lawyers from all over the United States, Silicon Valley, the Northeast, the Southeast, and the Midwest, and we all came to that same consensus. Entity selection has been a conversation that lawyers have been having since the beginning of time. And so it was great to hear that even today we all typically agree LLC is the way to start. I always try to explain to entrepreneurs kind of what the universe of documents are that come with every step that we take. And with an LLC, the universe of documents are articles of organization, an operating agreement, and then you typically will need an employer identification number or an EIN. Just to give you the quick understanding of what these documents are, we always like to describe the articles of organization as the birth certificate for your LLC. It's the document that's filed with the Missouri Secretary of State, and it lists some pertinent information about your entity. If you have a lawyer form your company, your articles of organization can list your lawyer as the organizer. If you don't, then you're typically listing yourself, and you often have to put an address, well, you always have to put an address, but you often will put your home address. And we've had stories of clients coming to us where they have disgruntled customers that are showing up at their doorstep because they found their home address through the Missouri Secretary of State's website. So just a cautionary tale. The next document is your operating agreement, and this is always a fun one to contrast with a corporation. So keep this in mind while I'm talking. I'll refer to it again in a moment. Your operating agreement essentially is the overall document that dictates how you govern your entity, how you run your LLC, but also how the members interact with each other. And there are various forms of operating agreement that you can use. You may wonder, why is my operating agreement so short when the person sitting next to me has a 70-page operating agreement? I could spend all night talking about this, but suffice it to say, if you're forming an entity and you're the sole owner of the company, you can have a really short operating agreement because ultimately you get to make all of the decisions about the company. If you have co-founders, multiple members to your LLC, then you have to go through and enumerate how you're going to make decisions, how you're going to bring on new members, how you're going to bring in new capital, what happens if one of you wants to sell, what happens upon death, disability, divorce, adjudication of insanity, which, by the way, I've never seen, but we always write it into the operating agreement. There are just a multitude of additional issues that come up when you have multiple members. And so if you're a startup with multiple members that's looking to raise capital, and you build, or you have your lawyer build, an operating agreement that has all of the provisions in it that allow you to grow into that place, you could be looking at a 50, 60, 70-page operating agreement. Whereas if you're a single member LLC, you don't need all of that at the stage that you're at. So operating agreements can look like different things. I could spend all night talking about it, but hopefully that gives you a sense. We always talk about the EIN as the social security number for the business. It's the number that you'll use with the federal government when you have employees, file taxes, etc. Okay, so formation of a corporation. As I mentioned on the previous slide, I'd like to compare and contrast the operating agreement with these documents here that are used when you form a corporation. So, universe of documents. I'll start with bylaws and the shareholders agreement together first, because the bylaws and the shareholders agreement together are analogous with what's in an operating agreement. It's just that with a corporation, we separate them into two pieces, right? The bylaws tend to deal with more corporate governance issues, whereas the shareholders agreement essentially addresses what happens or how the shareholders interact with each other. So with an LLC, you put those two things together in an operating agreement. With a corporation, you have two separate documents that detail essentially the same thing that goes into an operating agreement. Does that make sense? Okay, I see some heads nodding. So the consents are important both in an LLC and in a corporation, but there are some consents that are required when you form a corporation, so we put them up on the slide. We also have the EIN that we referenced on the previous slide. And what's missing from this slide are the articles of incorporation, that's the birth certificate for your corporation. We didn't list them again because it's essentially the same thing as what you would have with an LLC. Okay, so the question always comes up, S Corp versus C Corp. Those of you that have corporations, do you know, or who, maybe just a raise of hand, S Corp or C Corp? S Corp? Yeah? C Corp? Who's got a C Corp? C? I like that. C? C? Who's got an S? One? Okay, two. Okay. S Corps are a form of corporation, and you can also have an LLC that allows you to make an S election that sets forth how the corporation will be taxed, right? That's really the differentiating factor between an S Corp and a C Corp. C Corps are most often used for startups, whereas S Corps are most often used for a more lifestyle type business. And I always put that in air quotes because I feel like in the startup ecosystem, lifestyle business is kind of a dirty word. We have plenty of clients that are lifestyle corporations. The reason that you see startups using C Corps over S Corps is that S Corps limit you in the quality and quantity of shareholders that you can have, as well as the number of classes of units. With an S Corp, you can only have one class of units, whereas with a C Corp, you can have multiple classes. And so because corporations, startups who are using corporations often have multiple rounds and multiple classes of shares, we see C Corps used most often for startups. Does that make sense too? Yeah? Okay, excellent. All right. Confidentiality agreements. I'm going to talk a lot about confidentiality agreements throughout the course of this presentation because they're often a precursor in a number of different ways that you're going to interact legally. This is the only time I'm going to spend some time talking about confidentiality agreements, though. I'll just reference them in other places throughout the rest of the presentation. So a lot of people will say to me, Sarah, can't I just get a confidentiality agreement off the internet? And I say, sure, I get it, we're bootstrapping, right? But what they don't understand and what people don't talk about with confidentiality agreements is that they're only effective when they're very specific. And by that, what I mean is that you want to be really clear in a confidentiality agreement. Well, and let me roll back for just a moment. So the purpose of a confidentiality agreement is to protect confidential information that's being shared between the parties. They're often mutual, which means that if I'm sharing my confidential information with you, even if you think you're not going to be sharing any confidential information with me, you likely will at some point as we interact in whatever contracting atmosphere that we're in. And so confidentiality agreements are typically mutual. And they say, I'm going to share some confidential information with you. You're going to share some confidential information with me. We're both going to agree to protect it and only use it for a very specific purpose. So let me come back up here and talk about how these need to be narrowly tailored. So first and foremost, a very clear definition of confidential information is important. There's a pretty generic list in most confidentiality agreements as to what constitutes confidential information. But if I know that I'm sharing financial information with you as a part of a proposed transaction, I want to be really clear that my financial information is listed in the definition of confidential information. Maybe it's my year-to-date P&L and balance sheet for the last 3 years, as well as the last 5 years of my tax returns. I may want to specifically then list it in the definition of confidential information. And then use of confidential information. So you heard me say, we're going to share confidential information, we're going to agree to protect it, and then we're going to agree only to use it for a very specific purpose. So if we're contemplating a proposed transaction, maybe you're interested in buying my company, then I want to give a very clear statement in the confidentiality agreement that you can only use my confidential information for the purposes of evaluating a proposed transaction to buy my company. So really important, and that goes for all of these different flavors of confidentiality agreement that we've listed up here. If you have an investor that's looking to invest in your company, if you have an employee and that employee is going to come work for you, if you have an independent contractor, if you're doing general contracting, and we'll talk about master services agreements in a moment just because they're the Swiss Army knife of contracting. And then exit, if you're selling your company or you're buying another company. So we want to be really specific because it just gives us another layer of protection in the event that there's a breach of the confidentiality agreement. Okay, I know I promised that I would stop and pause for questions, and I forgot to do that when I was talking about entity selection. So let me pause now and say, does anybody have any questions on entity selection or confidentiality agreements? Yes?
was just wondering if maybe you could give a couple of sentences around some of the questions or concerns that we want to bring up with an attorney, or excuse me, not an attorney, but an accountant, based on the different selection types. What are the tax implications? What are some of the good questions to ask to find the answers you need for an accountant?
Yeah, I just had a conversation with a client about that today, and so it's a really great question. Without disclosing too much information or anything that's attorney-client privilege, the general issue that our client was facing today is that they've been the startup who's been in business for 5-6 years now, raised a couple rounds, and they're trying to figure out, is now the time to make the conversion from an LLC to a C Corp. They've been using profits interest to incentivize their employees and service providers, which is a mechanism of equity that you can use to incentivize with an LLC. And they're struggling just a little bit with what are called waterfall provisions, how distributions come out of the company when you have profits interest holders, and also the tax implications to the profits interest recipients. And I know I probably use some words that nobody understands, or some of you may not understand. It's not important for this conversation. What is important for this conversation is that they came to me and they said, well, what do you think, is now the time to convert? And I said the thing I always say, which is I'm not an accountant or a CPA, nor do I give tax advice. However, what we know about corporations is that when money comes into a C Corp, there's one layer of tax. And then when money comes out of a C Corp and is distributed to shareholders, there's a second layer of tax. And because that double taxation exists with a C Corp and does not exist with an LLC, some things to think about are, if as an LLC, have you ever distributed net cash flow to your members? Have you ever had excess money to distribute at the end of the year? And their answer was no, we never have. And so, if you're taking all of your excess earnings and reinvesting it into the company, is the double taxation as material to you? Because you're only seeing one level of tax, not two. So those are some really important questions to ask when you're talking to your attorney or your CPA about when is the time to convert. And I say when because, as I led with, almost always our best advice is start out as an LLC and then make the conversion if and when you have to, because you have the most flexibility from an entity standpoint as an LLC. Other questions you might want to ask your attorney, what kind of equity do you want to use to incentivize your employees or service providers? If you're very familiar with stock options and you only want to use stock options, in most interpretations of the law, you can't use options with LLCs. And I say most because there are some places in the United States that are trying to do it, but there isn't really clear guidance from the IRS on how to do that. So, understanding, what kind of equity you want to use to incentivize is important. I mentioned profits interest earlier with an LLC. If you want to use equity to incentivize your employees and service providers as an LLC, asking your lawyer how profits interests work, what that means to the cap table, how those tools will be used. So thinking as far ahead in the future as you can, and then trying to understand if there are any distinctions between using a corporation and an LLC.
One more question.
Please, yeah.
It's kind of built on that. So we had entrepreneurs before in Square One, and a lot of times they'll start, before they start the business, in maybe more of a consulting role. Mm-hmm. Is there any reason they couldn't do that under their own personal name? What are the pros and cons of jumping straight into starting an LLC? It sounds like the LLC would give them flexibility to build a business from. But do they need that when they're just doing some consultative work and they're getting paid for it, but they haven't really gotten where they want to go yet in their business, and not consulting business, just there's expertise there, they're developing a product line, and so they've consulted with people. Should they do that under an LLC? What advice would you give there?
Yeah, also a great question. And if we had all night to talk about entity selection, I would delve really deeply into some of this. But I'm glad that you asked, because I think it's important to really understand why we form entities in the first place. And a lot of lawyers don't talk to clients about this, really understanding like what's the purpose of having an entity other than everybody says I have to have one, right? The primary purpose of having an entity is that it creates a liability shield between you and the rest of the world. And that liability shield protects your personal assets like your home, your bank account, your 401k, anything titled in your own personal name is protected by the liability shield that comes with your entity. Now, you have to follow some rules to keep that liability shield intact. Otherwise, courts will do what's called piercing the corporate veil. And those rules are, the list is long, but some of those rules include things like having a bank account in the name of your entity, receiving all of the profits or all of the revenue for your business into that bank account, and then paying out of that bank account your employees, your vendors, your service providers. Contracting only in the name of your entity. Keeping it adequately capitalized. Adequately capitalized is a legal term of art that essentially means either keeping a certain amount of money in your bank account to pay your debts or pay in the event that you would get sued, or to have the appropriate insurance to cover those potential issues. And so if you're a consultant that's starting out, you're trying to decide, well, I'm servicing customers now, should I have an entity? My answer is always yes, and not because I'm a lawyer, but because the moment that you start providing services to customers, you open yourself up to liability. And I know for me, protecting what I've built so far for my family, protecting my personal assets is incredibly important. Going into business is risky enough, right? If you can do something as simple as form an LLC in Missouri, it's inexpensive and it's very simple to do, and follow a couple easy rules to maintain your liability shield, and that will protect your home and your kid's bank account or your bank account, your investments. I absolutely would do it.
Thank you.
Yeah. Go ahead.
So with the confidentiality
Yeah.
agreement between two parties that are in different states, how do you kind of handle the enforceability?
Or the choice of law provision.
How do you, when you're trying to write up or sign an agreement,
Yeah.
who gets the majority stake there?
Well, when I represent a client, we always try to get Missouri. And so we always ask for Missouri choice of law. If I'm in Missouri and you're in Kansas, or let's say California or Wisconsin, and we're negotiating a confidentiality agreement, and my lawyer wants Missouri and your lawyer wants Wisconsin, oftentimes we will settle on Delaware. Delaware has a robust body of corporate law, and there are questions about whether or not you have enough contacts with the state of Delaware for Delaware law to apply. But if you agree contractually that Delaware law will apply, there's a good chance it will. And it's kind of neutral ground, right? Choice of law is always helpful because if I were to win and we had Missouri, I would have home field advantage in any litigation. If it's Delaware and neither of us are in Delaware, we both have to travel. And so that could be a disincentive in and of itself to not file a lawsuit. Does that make sense? Cool. All right, in the back of the room.
So I have a situation. I wouldn't say that I'm asking for you to tell me what to do, but maybe.
But I'd love for you to tell me what to do.
But I have so this is the situation. I have an LLC, and we were accepted to this convention, this Web Summit convention in Portugal. So I have about 7 co-founders, more or less, and essentially we only have 3 tickets. So I bought the tickets for us to, because there's a little bit of a fee for the cost, and I paid for that. But then I told them that I wouldn't pay for their flights to the event, but still the other 2 are going to come. So we were given 3 free tickets. And so I guess my question is, in terms of when there's this fee for hotels, and if I pay for dinners, and since I paid for the tickets, I guess I'm a little bit worried because I don't want them to say, well, I paid for a portion of my expense, so now the corporate veil is not, I want to keep it as professional as possible. So in terms of what is okay to pay for them, what isn't, how not to give them an argument to say that, I was putting in more than I should have, something like that. That's
Yeah.
a question I have.
I mean, that to me, I don't mean to punt, but that to me sounds a little bit more like a bookkeeping issue than a piercing the corporate veil issue. Is it you personally that's doing the paying for the tickets, or is it the company?
So when I applied, I put my name and I was a contact person.
Mm-hmm.
So I guess my question is,
So ultimately, all of the expenses that involve the company, you want to run through the company's bank account. That's just good practice and good bookkeeping and what have you. It's pretty in the weeds for a piercing the corporate veil argument, but it is still, it could be one factor in a number of factors.
So what is, like, as I move along in this business, what is a good argument that one can pierce the corporate veil? What is it that I need to be very, very careful about?
Yeah. So let's say that I have a company, ABC LLC, and the two of us enter into a master services agreement, which I'll talk about in a moment, where I'm going to provide services to him. And instead of entering into it in the name of my company, ABC LLC, I write Sara K. Stock in the contracting party, and I sign personally. It's hard for me to then come back and say, oh, no, that wasn't me. Personally, it was ABC LLC. I just forgot to write the name in the party, right, as a party to the contract. So that's a pretty egregious example. Yeah.
It's my understanding that the owners, members, managers, whatever you want to call them, and I'll say, do not have to be natural persons. If I have a trust, I can designate that trust to be my representative. Or if I have an LLC, I can designate that to be one of the co-owners of another LLC. And can that be used to create still another layer of insulation between you and liability?
Yeah, yes and no. I think we could probably talk all night about that, but ultimately, here's the 30,000 foot view. We have a company, you and I, ABC LLC. If we do all of the appropriate corporate governance things, the veil will never be pierced, right? And so if we pierce the veil and at the next level there's another LLC, well, now we have the same piercing the corporate veil and piercing the corporate veil and piercing the corporate veil. So, yes and no, but really best practice is just to abide by the corporate governance principles at the operating company level, and then there's no reason for that. It's just excess legal work and administrative burden. So that's always my kind of general advice. Yeah?
It's a simple question about, you mentioned like following the rules of your particular entity or just liability.
Yeah.
And like you said, it's very simple to go online and create an entity. Where do you find like
These corporate governance
official-
rules,
Yeah.
they don't exist anywhere. It's not black letter law, unfortunately. So much of it is determined by case law. And so that means that a judge has made a determination in a case as to what constitutes appropriate corporate governance rules. So unfortunately, it's not something you can Google. It is something you have to talk to a lawyer about. Any other questions before I move on? Yeah, right here.
Confidentiality agreement.
Yeah.
So, in the event that you're trying to raise capital, as an example, and you're doing, say, an accelerator program or any of those programs to help you essentially raise capital at some point, how would confidentiality come into play at that point?
Yeah, so with any investor, my rule of thumb is it never hurts to ask. I say it's a rule of thumb because there are some venture capital funds out there who, it's well known, will be offended if you ask them to sign a confidentiality agreement. At this stage, you're likely raising money from angel investors. Not necessarily all the angel groups, but most angel investors will sign a confidentiality agreement before you provide them with your financial information, your business plan, your projections, sources and uses, etc. And so I know that's not a really good, clear answer, but there really isn't a great, clear answer. Suffice? Okay, cool. Yeah.
I had a question and comment. Comment to that was just like, I know probably angel round are seeing fewer deals than a VC would, so a VC might say like, I don't want to spend a legal fee to negotiate this every single time that we have a company come through versus a family and friend is like, I know you, I'm probably only working with you and like 10 to 100 others, so
Yeah.
it's just a smaller deal.
Totally.
And then there's a question around, so if you have a co-founder and your company is set up in a different state, but then you're setting up things like PO box or other things, are you in some ways, is there any kind of requirement to set up the manufacturing facility or PO box or anything on other, or like setting up barcodes and things like that? Or is it better to set it up in the state that you are incorporated in, or is there no legal issues?
Yeah, so if I start a company in Missouri and then my company is going to do business in Illinois, because that's where I'm gonna build my manufacturing facility, I have to register to do business. I have to register my company to do business in Illinois. If I hire an employee in Kansas, even though he or she is working remotely, I have to register, generally speaking, have to register my entity to do business in Kansas. And so it's really just registering the entity to do business in a different state.
Okay.
Does that make sense?
Yeah.
And the downside to that is that once you register to do business, you may have to pay annual fees, file annual reports, pay tax in that state, et cetera. So.
And I'm sure it's like manufacturing employees and like what, there's like specific use cases where you have to register? Okay.
Yeah, I mean, the independent contractor is a kind of a gray area, right? And all states have different rules, so I can't really make like a blanket statement. But generally speaking, those are some principles that you can follow. Yeah, right here.
We've got.
So much more to go through.
Yeah, I'm going to let it be your call because I'm watching the clock.
Okay.
We've got about 14 minutes if we could hold them all together,
Yeah.
recognizing that I started this waterfall. I apologize. I think the was awesome. And
No
I loved
worries.
every minute of it.
Yeah.
But I don't want to deny you your opportunity to get to the material.
I appreciate that. Yeah, and you can always email me afterward too. So I want to talk a little bit about capital raise documents because I get comments from clients all the time clients will say things like, this feels like a tariff that I have to pay in order to raise capital. I have to pay these legal fees. I don't understand why I have to do these documents. Why do I have to pay a lawyer to do this, right? And so I like to give the 30,000 foot view, and I'm going to speak in like sweeping generalities, just for the purposes of trying to break it down into something that you can understand. So 30,000 foot view is that the Securities and Exchange Commission requires the issuance of every single security, a unit in the LLC, a share of stock, to be registered with the SEC. And that registration process is expensive and it's time consuming. And so ultimately, your job as a startup founder who's raising capital is to find a way to not have to register the issuance of your security with the Securities and Exchange Commission. There are two big buckets of ways to do that. The first is under Section 482 of the securities laws, which essentially says if it's a private placement, very generally, you don't have to register with the SEC. It's ambiguous as to what constitutes a private placement. So, I wave my hands around like it's magic when I say it, right? The other is much more specific. It's a safe harbor under Regulation D. And there are many safe harbors under Regulation D, and we lawyers like safe harbors because there are boxes that we can check. And if you check all the boxes, then you qualify for a safe harbor. Maybe we file a Form D at the end of the issuance, and we know that you're safe. Why does this matter, right? Well, if ultimately you don't provide to investors a disclosure of all of the material information about your company, and what constitutes materiality, right? That's the $1 million question. My rule of thumb is that if you don't want to tell an investor about it, it's material, okay? So somebody's threatening to sue you, I don't want to tell my investor, that's material, right? So if I'm investing in your company and you don't disclose to me all of the material information about your company, and ultimately your company goes bankrupt, goes under, I lose all of my money, right? Well, I can say, I didn't know, you didn't disclose that material information, and I can essentially sue you personally for securities fraud. Now that's a sweeping generalization and oversimplification, but remember we talked earlier about why you form an entity, that liability shield. This is, and follow the rules, they won't pierce the corporate veil, this is the same thing. Follow the rules, and you protect your personal assets. And so because your personal assets are at stake, that's why this is so important. So what are these documents? What's the universe of documents involved when you raise capital? It can be a number of things, right? It's almost always a confidentiality agreement and then a term sheet. I'm assuming most of you know what a term sheet is, so since we're a little short on time, I'll skip forward. One way to go when you're raising capital to disclose all of that material information to potential investors is a private placement memorandum. Everybody heard of a private placement memorandum? Disclosure document, very detailed, often very expensive. Essentially, you provide the lawyer a bunch of information, we read it, and then we regurgitate it into something called a private placement memorandum or a disclosure document. Because that's such an expensive process, we're always trying to find other ways around it. The way that we do it at Stack Legal is we build an umbrella subscription package for our clients that contains all of the same components of a private placement memorandum. We just ask you to provide a lot of the information. We read it, but we don't then regurgitate it into a private placement memorandum. And so up here is kind of how the subscription package plays out. It's a set of instructions to the investors, including things like where to send funds, who to contact for more information. The subscription agreement, which it drives me nuts that lawyers call it a subscription agreement. It's a purchase agreement whereby an investor buys securities from your company. And then we include it as exhibits if you're an LLC, your operating agreement and your joinder, which joins the investor as a member to your company. If you're using a convertible note, the convertible note form. And then risk factors, which essentially say, you investor know that this is an inherently risky investment and you're likely to lose all of your money, except we do it in like 10 pages of text, right? An investor questionnaire, which determines if you're an accredited investor. And then we include as exhibits your business plan, your projections, and your sources and uses. I know I went really fast, but I have more material to get through. Does anybody have any questions on what that looks like? No? Okay. So then let's talk a little bit. I like to throw this slide up there just to remind startup founders that there are other methods to bring equity into your or bring money into your company through traditional loans to the extent that you have the appropriate net worth, or if your company has 3 to 5 years of financials, you might be able to get likely a secured loan. So that's just a reminder. Okay, so general contracting. I think this is important because as you're going through the life cycle of your company, right? Step 1 is I'm going to form an entity, right? Often step 2 is, well, now I've got this entity, I need to raise some money because in order to get my idea to an MVP, I'm going to need some capital to do that. Well, then you get to a point where you have a thing to sell. What are you going to do next, right? Often step 3 is some sort of general contracting. And I lead with the confidentiality agreement again because you might use it prior to talking with an employee, prior to talking with an independent contractor, or prior to entering into a master services agreement. So why are these things important? So employment agreements in the startup world aren't really employment agreements for the most part. They're confidentiality, non-compete, non-solicit, and invention assignment agreements. And in fact, that's the title. That's really long, right? The reason for that is that when you say an employment agreement, you signal that there's a term to the employment agreement. Most startups engage with an employee on an at-will basis, and so it's not truly an employment agreement. But the components that I just mentioned are really important. At-will means that you can hire and fire at any time, or the employee can quit at any time. The non-compete and non-solicit are pretty important. Non-compete says that the employee can't go next door and open a business that looks just like yours for a certain period of time and in a certain geographic radius. Non-solicit typically means 2 things, one of which is that you can't solicit customers as an employee once you leave the company. The other is that you can't solicit employees when you leave, and typically, again, for a certain period of time. Invention assignment means that if I'm an employee while I'm working for ABC LLC, I come up with a fabulous idea that's going to benefit ABC LLC. The language in this agreement says that essentially I assign the rights to that idea to the company if I come up with it during business hours or some other constraints around that. Independent contractor agreements are often the very first way startups engage with the workforce. I did an hour-long presentation on independent contractor agreements at RISE, so I will try to, again, condense that down. You know, the gig economy is a thing, right? People are really looking to work work that way, and so finding great talent that way is an awesome opportunity. Essentially, independent contractor agreements have a lot of the same components as that at-will employment agreement that I was talking about. Sometimes we write non-competes into independent contractor agreements. There's a whole body of Missouri law that would argue that non-competes are unenforceable in independent contractor agreements. Sometimes they're written in anyway, just as a scare tactic. But non-solicitation typically is enforceable. Invention assignment typically is enforceable. We like to ask the independent contractors to carry some sort of insurance because they don't owe some of the same duties that an employee owes to the company. And then I mentioned this 20-factor test up here. The IRS has a 20-factor test to determine if you're an employee or an independent contractor. The Missouri Department of Revenue is really cracking down on independent contractors. So I guess in the time that I have, I'll just simply say, if you're thinking about engaging with an independent contractor, definitely take a look at the test. Talk to your lawyer about it. Make sure that you really are treating your independent contractor as such and not looking to bring someone in as an independent contractor for a number of reasons, but really they're acting as an employee. Does that make sense? Cool, lots of head shaking. Okay, great. And then a few words about the master services agreement. I mentioned earlier, I call master services agreements the Swiss Army knife of contracting. That's because you can use them for so many things. You can use them as a consultant when you're providing services. You can use them as a company that is providing a service, but you're not quite SaaS yet. MSAs have a wide variety of use, and in fact, if you're a company that is not in the service industry at all, but you're engaging with vendors, your vendor is providing a service to you, so master service agreements come into play there. What we like to say about master services agreements is that if they're well drafted, they're set up so that you can attach multiple schedules of work to them without amending the master services agreement. Clients are so annoyed when they call me and they say, all right, we're doing a new schedule of work with this customer. The MSA that our old lawyer gave us has to be amended every time we change the schedule of work, and now I have to pay you X hundred of dollars to draft an amendment. You can set them up so that they contemplate multiple schedules of work that can be appended to the back and signed by both parties. All of the documents up here are documents that a lawyer can easily template out for you, empower you with the information about how to use it, and Stock Legal does all of this work for a fixed fee. Okay, any questions on those? No? Okay. I have to end by talking a little bit about exits, and I'll say just a few general words about exit and why it's important to you now. Every time I talk to this group, I always see people, I can feel the thought process going like, why are we talking about exiting? Like, we're just starting a company. We always talk about the end in the beginning. It is incredibly important to understand what the trajectory of your company looks like today because it helps build the legal path for you. There are 1,000 iterations of facts that you could present me today that would lead me down 1,000 different paths, and I would give you different advice depending on whether or not you are building that lifestyle company or you're building a true startup that's going to raise capital and exit in the next 3 to 5 years, kind of two ends of the spectrum. So what does an exit look like? Again, the universe of documents here, right? The universe of documents, again, starts with a confidentiality agreement. And then M&A, or mergers and acquisitions transactions, usually come in two forms, either an asset deal or a stock deal.
5-minute warning.
Thank you, I appreciate that. And I'll give you a quick story today, a quick story about a client that we had today. Again, not disclosing too many facts, not breaching attorney-client privilege. We're representing a client that is living the dream right now. First-time entrepreneurs, started their company 3 years ago, in a position where, you know, they could sell their company for double-digit $1 million next year. But a customer has come in and said, we want to buy you today for about half of what you'll be worth next year. Here's a letter of intent. And they called us giddy. They're like, oh my gosh, look, we got it. Like, I think the deal's going to happen, right? So our first question was, well, what is the deal going to look like? Is it going to be an asset deal or is it going to be a stock deal? And then how's the purchase price going to be paid? Because it's incredibly important to try to get as much of the purchase price paid in cash up front. And not have it subject to something called an earnout to the extent that you can prevent it. Earnouts are, I like to call them casino money. There's often strings or contingencies attached to the earnout that only get paid when certain things happen and you can't predict the future. So let me get back to the slide for a minute. Asset purchase agreement essentially looks like this. A company comes in and says, I want to buy all of the assets or all or substantially all of the assets of the company. You say, okay. The process that you go through to sell your company in both situations, an asset deal or a stock deal, starts with that confidentiality agreement. Second comes a letter of intent. And typically, we're negotiating the deal documents while the buyer is running due diligence. That typically happens on parallel paths, and then we do what's called a sign and close. When someone's buying just the assets of your company, what they're saying is, I don't want any of the liabilities, or I don't want most of the liability associated with the company. I just want your assets, and then I'm going to bring them inside my company. The deal that we're talking about today is a stock, that my client was talking about today is a stock deal. What a stock deal says is that, you know, the way a stock deal looks is that a buyer says to you, I want to buy all of the stock of your company, Mitch. And I'm going to step into the shoes of you as a shareholder or as a member if you're an LLC. It's an interesting play because you as the buyer then get all of the liability associated with that company rather than the limited liability you get as a buyer when you buy the assets. The reason that our deal is set up as today as a stock deal is that there is an earnout attached to it, and that earnout is dependent upon the company that they're buying producing a certain level of what's called EBITDA, or earnings before interest, taxes, depreciation, and amortization. EBITDA is a standard of valuing a company that's usually attached to a multiple when you buy a more traditional company. It's not something that's typically used with a startup, but because this company is growing and scaling, they want to attach an EBITDA contingency to it in order to pay out the rest of the purchase price. Okay, I know that was a lot of information. This is my overview and conclusion. These are the 5 things that we talked about. I've got about 90 seconds left. Who's got questions? Yes.
So my question back to the confidentiality agreement.
Yeah.
If it's, like, if you get one off the internet, is it ever enforceable?
It's not that it isn't, it's not that it's unenforceable, right? It's that, you remember the 2 most important things about a confidentiality agreement are that you've built a great definition of confidential information that actually protects the thing that you're trying to protect. And the second is that it limits the use of that confidential information to the specific purpose at hand. And if you get one off the internet, generally speaking, it doesn't have that specific purpose built into it, and it probably maybe doesn't mention the kind of confidential information that you want to protect, and it definitely doesn't mention it specifically because it's just a plain vanilla confidentiality agreement. Yes?
Is there, if there are 2 different ideas for 2 different companies, would you suggest doing 2 LLCs or just 1 LLC? Even though they're the same theme?
Yeah, that's a great question, and I see that a lot. People will come to me and say, hey, I have 3 businesses. I have 1 LLC and 2 DBAs. Everything's protected, right? No. that, and I'll give you an example that's tangible in the last 10 seconds that I have, in the last non-seconds that I have. And that is that if I'm a real estate developer and I go out and buy 2 apartment buildings and I put them in one LLC, apartment building A and apartment building B. And in apartment building B, someone slips, falls, and is killed because of my negligence. A plaintiff's attorney is going to sue my LLC, and there are 2 assets that they can go after, apartment building A and apartment building B. If I set up 2 companies, and company 1 buys apartment building A and company 2 buys apartment building B, same set of facts, right? That plaintiff's attorney is going to sue this LLC over here that only has 1 asset in it. Different business lines, unrelated business lines, are just like building A and building B, right? If you put them in separate LLCs and you abide by the corporate governance principles that we talked about, you build some insulation around those assets to protect them. And so that's why we always say two different businesses, 2 LLCs. Thank you all very much for the opportunity to speak with you tonight. I appreciate it. Thank you.